Welcome to the 2021 series of Business of Tennis webinars presented by the Tennis Industry Association UK, the not-for-profit members organisation open to anyone working in UK tennis. Today we hear from an industry expert on the importance of trademarks and brand protection for companies in the tennis sector. We will also hear about the benefits that clubs and organisations could gain from considering protecting their brands holistically and robustly.
Hello and welcome. My name is Desiree Fields and I am an intellectual property solicitor who's specializing in trademarks and brand protection. And like everyone watching this webinar today, I'm also hugely passionate about tennis. Now in this webinar, I will consider and illustrate the importance of trademarks and brand protection for established companies as well as startup companies who are active in the tennis sector, as well as the benefits that sports organizations and tennis clubs who are active in the tennis sector would gain from considering protecting their brands holistically and robustly, as well as providing a basic overview of how trademark and brand protection works in practice and what elements of a brand can be protected. The webinar will also cover common pitfalls and provide some strategic advice for brand owners to consider in taking their brand protection forward or improving upon the current levels of protection. Now going on to the first slide, what is the schedule of play for today? Now the very first thing that we want to look at is what is the ACE card here, the importance of trademarks brand protection in the sports industry and the tennis sector. After that, I will move on to give some basic illustrations of the importance of trademarks and brand protection in the world of tennis by looking at some real life examples of brands that we all know very well. After that, we will go on to the meat or the rally of the presentation, where I will be giving a brief overview of all the intellectual property rights which are relevant to the sports industry and the tennis sector, before then diving into those things that you might consider not so good, the common pitfalls and mistakes that some brands make when they are considering trademarks and brand protection. And then we move on to some top protection tips so that you have your winner cards in the back pocket. And finally, what I also want to discuss is what is the real value of brand protection to tennis brands and tennis clubs, so that you have a bit of an idea of why you should be going forward with considering your brand protection. Now, looking at the first point, what is really the importance of trademarks and brand protection in the sports sector or the tennis industry? Now, as you will know, the sports industry is really a hugely competitive sector with some of the world's largest companies competing in this field. Intellectual property rights are really at the heart of any commercial opportunities that you may be looking at and that are offered by the world of sports. So you will all be aware how valuable, for example, broadcasting rights are to the economic value of the sports sector, including tennis, which was brought home even more during the pandemic, actually, because it was clear that even without an audience, there is really a huge economic value in keeping tournaments running. And intellectual property rights, of course, also play a huge role in the growth and development of the sports industry, as they are at the heart of a number of business transactions, such as sponsorship and also merchandising. Now, what is also true is that consumers today have a really unprecedented level of choice. And as such, it's really important for brands to distinguish themselves from their competitors. Now, in that regard, the importance of intellectual property rights, and in particular, the importance of brand protection, really cannot be underestimated. Businesses which operate in the sports sector rely heavily on brand awareness and brand loyalty for their success and creation of business value in turn. So generally, the stronger a brand is and the more investment that you make into a brand and robust brand protection, the more valuable it becomes. And having a good trademark portfolio, a brand protection strategy in place, allows a brand basically to move ahead of its competition, provides a winning start for new brands, or is a powerful move for established brands. Now, of course, businesses in the sports industry can utilize numerous IP rights, including copyrights, trade secrets, and patents. Given my personal background and experience as a trademark and brand protection lawyer, I will mainly focus on this area in this talk. However, please do bear in mind that there are other aspects to consider, and so I'll give a brief overview of those as well, so that you have a little bit of an understanding and can recognize which fields of IP protection are actually important And these play a role in areas such as e-commerce, merchandising, sponsorship, advertising, and commercial agreements. Now, the first thing I want to do to make this more exciting for all of us today is give some illustrations of the importance of brand protection in the world of tennis by looking at some real life examples that hopefully we all know about or have at least seen somewhere. So let's put this into context. The first thing that you see on the slide is the very, very famous RF logo, which is of course associated with Roger Federer. And as anyone in the tennis industry will know, Roger Federer had a very long relationship with Nike during his career, starting at the age of 13. And as part of his outfits and branding, Federer always wore gears embossed with the famous RF logo. Now, RF is, of course, the initials for Roger Federer, and those are his initials. But interestingly enough, it was Nike who owned the registered trademark rights in the logo around the world, and Federer only owned trademarks for his full name and signature in his own name. So this is very interesting, of course, because quite recently Federer parted way with Nike and moved to Uniqlo, which was a deal that was reportedly worth about 300 million US dollars, I believe. And one potential issue that trademarks and brand protection lawyers would have looked at here is, well, in the absence of an agreement between the parties, what does the continued use of the RF logo by Federer mean? As long as it was owned by Nike, actually, technically, using his own initials or using that logo would have infringed Nike's trademark rights. And that's quite an interesting thing to think about when you're looking at who's owning the trademark rights. Now, ultimately, the RF initials are now owned by Tenro AG. This is Federer's company, and they have been assigned to him in or around 2020. However, it is clear that the RF logo, of course, had immense brand value and still continues to have immense brand value for both Nike as well for Roger Federer personally, because, of course, these are initials that his fans recognize. His fans are very keen on getting clothing that has the RF brand on it. And so it's a very, very strong brand. Of course, there's other really, really strong brands in the tennis world as well. And just one, well, actually two examples, Fred Perry and Henri Lacoste, they have formed clothing lines under their names. And I mean, these are really multi-million pound businesses, and everybody knows these clothing lines in the tennis industry. And the other thing that is really important to note is that actually both Fred Perry and Lacoste are very, very active in the trademark and brand protection sphere, and they heavily enforce their rights. Especially if you look at the famous crocodile logo for Lacoste. Lacoste has been involved in significant trademark enforcement programs over the years. And one example that I've put here on the slide, a cute little crocodile on your left. This was actually a crocodile that a children's brand called Hema was using on children's clothing, and Lacoste took successful action against them. And so the crocodile unfortunately had to be removed. But it just shows what a huge value it is. Crocodile on clothing, Lacoste is quite associated by the public, and immediately so. And then another favorite of mine is Wimbledon, or the All England Lawn and Tennis Club. Now, as I will touch upon a little bit later in this presentation, trademarks are not limited to names and logos, but they can also cover other branding aspects. And by way of example, it can be possible to register so-called non-traditional trademarks, such as colors. And in that regard, of course, the colors green and purple have been associated with Wimbledon for well over 100 years. But until fairly recently, the All England Lawn and Tennis Club did not have any trademark registrations for these colors, having to instead rely on the kind of unregistered rights and the goodwill and reputation that they built up in those colors in association with Wimbledon to try and prevent third parties from taking advantage of that goodwill and trying to create an association with Wimbledon where no such association actually existed. Now, really excitingly, in 2016, the All England Lawn Tennis Club succeeded in registering two color trademarks depicted on the slide here. And you'll see you have vertical green and purple stripes and also horizontal green and purple stripes with the very famous Wimbledon color scheme. And these colors are now actually protected amongst other goods and services in respect of things like publications and tennis clothing, as well as broadcasting right and organizing and staging tennis competitions and related services. Now, I would say that this is really a major success, having achieved these registrations, because what it now means is you have registered trademark rights that you can enforce against third parties that are trying to kind of take advantage of all the value you've built in your brand over the years. So now diving into the nitty-gritty of trademarks and brand protection, let's look at overview of IP rights now. So this is more the legalistic things, but it's really designed to give you an overview when you're looking at your brands. What are the things that you can protect? What should you be thinking about? And how should you really be thinking about your brand protection? What aspects do you need to consider when you're moving forward with that? Now, as I said at the outset, really trademarks is the focus of today's presentation, and registered trademarks are really the primary protection for a brand as they identify the brand and they are the label under which goods and services are offered to the public. The purpose of a trademark is really to indicate the origin of goods and services, and as such, they must be capable of distinguishing the goods and services of one undertaking from those of another undertaking. So what does that really mean? Trademarks act as an indicator of origin. And this means that in order to be registrable as a trademark, the chosen name must not be descriptive of the goods and services that you're applying for or lack distinctiveness. By a way of example, world's biggest tennis bag for a tennis racket bag would not be registrable as a trademark, as it tells consumers exactly what it is, and you cannot monopolize those general words. Similarly, it would be very difficult to register words such as East London Tennis Club in relation to the provision of tennis facilities and related services, because again, it would be descriptive and it would lack distinctiveness in relation to a tennis club, say, based in East London. Indeed, there may be more than one tennis club in East London, and so it would be quite unfair, actually, if you were able to monopolize this, because other tennis clubs in the area would feel quite strongly that they're also an East London Tennis Club. And so it would not just exclusively refer to one club in the area. So again, in order to gain protection for such a mark, it would either be necessary to add something distinctive to the mark. Distinctive elements could be, for example, a logo or another word that makes, that it doesn't directly describe what you're doing. Or alternatively, if you're a very famous tennis club, even if it's a descriptive kind of name by way of location, if you use that for a long period of time and people in the area have become accustomed to the fact that this is your brand and nobody else's, then there is potentially a chance that you could apply to register the trademark on the basis of acquired distinctiveness for use. Now, that kind of route actually requires a lot of evidence. You need to submit extensive evidence that shows that mark concern has over time become known by the public through the use that's been made of it as being associated with the goods and services of one particular company or club and no other. Quite a tricky topic, which is outside the scope of today's presentation, but interesting to be aware of that, it's not always fatal if you have a descriptive mark, but generally you should be looking for something that's not descriptive and that's distinctive when you're looking at branding. And really the best trademarks are therefore those that consist of made up words with no immediate identifiable meaning. For example, Yonex in relation to tennis rackets, or words which have no meaning in relation to the particular goods and services concerned. For example, head again has no meaning really in that kind of sector. So when you have a trademark, what rights does that actually give you? Now, a trademark gives exclusive rights in the particular mark concerned and a right to you to prevent third parties from using the same. However, what is really important to note is that trademarks are territorial in nature and are only protected in those countries where they are registered. So when you are looking at a trademarks and brand protection strategy, you really need to think about, where do I need to register this trademark? Is the UK sufficient for local tennis clubs? Of course, it could be. But if you are a bigger brand and you're thinking about branching out now in the future, then you might need to look a little bit further than that and also see whether you need to protect in other countries and where these countries are and kind of devise a strategy around that. And other things that you do need to consider when you're looking at trademarks and brand protection is, what are the different types of trademarks that you could register? So for example, as I alluded to earlier, there are many different branding elements that may be protected by trademarks. These generally fall into two categories, so-called traditional trademarks and non-traditional trademarks. Now, so-called traditional trademarks are usually those that consist of words and logos. So something that you're really, really familiar with, only looking around a tennis court, you'll see them everywhere, really. And all companies that exist, I mean, no matter how big your business really is, there will be a name or a brand at least. And usually for most businesses, even small ones, there's also a logo. And these types of trademarks really form the bulk of trademark registrations on the various trademark registers globally. I would say 99% of all trademarks really consist of these so-called traditional trademarks. Now, non-traditional trademarks are quite exciting, really. I quite enjoy this field, I have to say, because it goes beyond that. And what non-traditional trademarks could include are things like sounds and colors and product shapes, smells, tastes, textures, motion marks, and holograms. However, such trademarks are really difficult to protect, and they tend to form only about 1% of all trademark applications because they often get rejected. For example, registering a shape of a bottle, it's really hard because you have to show that it's unique and not common in the marketplace to get a registration, or show that consumers would only associate your product with this particular shape. An example that actually again relates to the tennis industry is quite interesting, of a non-traditional trademark that succeeded many years ago, was that of a Dutch company who actually registered a smell or a scent trademark for tennis balls that smelled of fresh cut grass. Now, this is a very controversial decision. It always gets cited as an example for non-traditional trademarks. The trademark is actually no longer active, but it's really interesting to see. So it's really worthwhile thinking that if you have a creative brand, is there anything beyond my word and logo that I want to protect? Again, it's a very complex topic, which is outside the scope of this webinar, I'm afraid. But it's important, again, to be aware of this. So when you are looking at your trademarks and brand protection strategy, and you're speaking to people that are helping you shape that, and your lawyers that may help you with registrations, to just raise it and see whether it's worth considering further. The another nice thing about registered trademarks is actually that they can be protected indefinitely. So provided you pay the relevant trademark renewal fees every 10 years, the trademark registration can subsist forever. And that's actually one of the rarer IP rights that you have forever, really. This is why it's such a strong tool, really, in your branding and company protection. So the other thing that I really want to touch on too is like trademarks can also be unregistered, actually. Registered trademark protection is the strongest form of protection, because actually when you are you want to complain about a third party using a mark, you just wave a registration certificate at them and you show that you have these registered rights. Unregistered rights could also subsist in a brand. You'd have to then show a reputation and goodwill in the marketplace in these unregistered rights, which means submitting again a lot of evidence to show that it is a recognized trademark in the marketplace. If you want to try and prevent other people from using that brand. And this is how you would enforce that, is under the so-called common law tort of passing off. So you're showing basically that there is a reputation and goodwill, that somebody has been using the mark and that has created a misrepresentation to the public that they're associated with you, and that causes damage to your brand. But these cases aren't that easy to prove, and that's why we always say that you should strongly consider registered trademark protection if you haven't already done so. And yes, unregistered trademarks can protect, again, the brand name, the goodwill and reputation, and it also can protect things such as, packaging as well. Now, moving on slightly from trademarks, but very, very closely related to that, actually, are design rights. So the design rights often go hand in hand with trademark rights, but are sometimes overlooked, actually. What design rights protect is the appearance of industrial reproduced products, and that's both they're both like registered designs or unregistered designs, which arise automatically. Registered design rights would also be obtained by applying for registered design protection. Design protection is really important in sectors such as fashion, but actually it can affect all commercial goods. And really what it is intended to do is to protect novel aspects of a product and its packaging. And so it's useful protecting certain stylistic elements of a product that might not qualify for trademark protection otherwise. Now, in the UK, a design right automatically protects designs for 10 years after it was first sold or 15 years after it was created, whichever is the earliest. EU unregistered design rights are only protected for 3 years, and UK and EU registered designs can be protected if they're registered for a maximum of 25 years, provided relevant renewal fees are paid every 5 years. So it's quite a nice long term, but it's not forever, unlike trademarks. Now, then we also have patents. Patents, people might not think immediately about, but actually they do exist, and in the tennis industry. And what they do is they protect inventions. What a patent also does, it grants the inventor a property right to exclude others from making, using, offering for sale, or selling the invention. And it's really relevant to those businesses that use innovative technologies. Mostly, we always see that in the pharmaceutical medical device sector, but also electronic industries. And really, the example that you must have seen a lot lately in the tennis world, especially recently during the pandemic, is Hawkeye system. And the patent technology behind that really involves a high-speed camera system that tracks the path of a ball and a heat-sensitive camera that will scan for the heat spots to see where balls land. And that's how it then records the decision whether it's out or an in. Quite an interesting technology, actually. And in terms of patents, they have a limited length of time. If you have a patent that you want to protect, it's up to 20 years, provided renewal fees are paid. There's a lot to consider around patents, which I won't go into detail to, but one of the things is if you're considering a patent, you need to think about keeping that quite confidential at the outset, so that you don't lose the chance to protect your patent. So if you have a great invention, think about whether it is patentable and get some advice around that too. And then copyright. Copyright, again, interesting, right? It arises automatically. You don't have to register it. What it does, it doesn't protect any ideas. So if you have an idea, that's not protectable. But what it does protect is the form of expression of a particular idea, provided the work in which the idea was expressed is original and involves independent skill and labor. So it protects things like product descriptions, images, pictures, drawings, films, music, software, consumer, and sales details. Length of protection is variable, but for most copyright works, so the standard ones like musical or text or images, it usually is 70 years from author's death, but it can vary depending on the nature of the work. And then finally, just to touch upon one IP right that is also on the side sometimes, confidential information, very relevant to businesses if you are working with people, collaborating, creating certain ideas. If there's something commercially sensitive about it, it's always good to put a confidentiality agreement in place. It protects things like customer, supplier information, know-how, manufacturing process, and product launches. The length of time of protection is variable. You can put that in the terms of agreement. You could put it forever, but usually what you find is that confidential agreements last about 3 to 5 years. Now let's look at the common mistakes and pitfalls that you might find in trademarks and brand protection on the next slide. And unfortunately, we do see this quite a lot, even with established companies. So what I wanted to highlight is the things that you really should think about and look at the implications when you are not dealing with things in the way that they should be done, or what the consequences could be, for example, if trademark and brand protection is neglected a little bit. Now, the first point is some companies don't give enough importance to brand names, trademarks, and logos. There's big companies, for them, branding is clearly everything, especially in the consumer goods sector. But for other companies, it may be an aspect of the business that is given less importance or weight, especially during the development phases. And so we have seen on many occasions that companies are developing products or services, and then they realize within weeks or sometimes even days before the launch that they have not really given any thought to their name, their branding, and their logos. And sometimes they may even launch without having given any thought to the branding. So what is the implication of this? In some instances, it may be the case that no advice has been sought around the particular branding to be adopted, and it turns out that the mark is not terribly distinctive. So what companies may then find is that they later on try to protect their name but cannot obtain a registration for their name or their mark. And this then makes enforcement against third parties much more difficult. And it may be that the brand value is then diluted for that very reason. Or in some ways worse, companies may find that their chosen branding is already in use and find themselves at the end of a potential trademark infringement action with the prospect of having to rebrand. And this means that you may face substantial unexpected legal costs to deal with a dispute, as well as the costs of having to rebrand. So this could be quite a substantial thing. Now, related to that point, actually, and this is quite similar, is, again, you're thinking about brand protection too late. And so what we have seen many times is that companies, they develop their brands or their marketing campaigns without carrying out any relevant trademark clearance searches to determine whether a brand is available for use and registration. And this can lead to unexpected third-party objections along the way with a potentially hefty price tag, again, relating to solving the disputes or also having to rebrand. And in other cases, companies may think about carrying out clearance searches, but they leave them to the last minute. So what you find is days before launch, suddenly you have to do these clearance searches. There's no time to conduct them anymore. Or you had a name that is really problematic, and then there is no way to actually find a new name because you've already announced your launch, and you can't actually change that prior to launch anymore. So there could be major decisions involved as to whether you take the risk and launch and see what happens, or whether you simply continue, or whether you then postpone the launch, perhaps. So various things have to be considered then if you leave it all too late. Now, other things that we have touched upon earlier, I briefly mentioned, what we often do find is that companies like to choose descriptive or generic names for their products. And this is a major pitfall that we encounter very often in marketing campaigns, because marketing companies do like to choose names which are descriptive of a product or service. I guess it's because it tells consumers what it does, so it seems natural that you would do that. But for example, if you had ball feeder for a tennis ball feeding machine, such a name is really not registrable because it doesn't have any product differentiation, and it will be difficult to protect, if at all. Thinking about maybe you put a logo next to it, but if you put a logo next to it, it's only protected with the logo and not on its own, so that other parties could name it exactly the same thing. Related again to timing, and you will see the message that I'm giving is think about brand protection early, is that we also often find that trademark applications are filed after use commences rather than before. Again, we often see that companies start using a brand, they don't have the registrations or applications in place, which can be very risky. Again, it is because maybe it's not protectable because it's descriptive or lacks distinctiveness, but also other parties could come into the market, sometimes even after you. So you may have not applied for a trademark. Another party comes a few days or months or weeks after you're in the market with a similar or the same name, but they think about registration and they start, they put the registration in place. Then you have a bit of a difficult situation because yes, you used first, but maybe they weren't aware of you, maybe they become the bigger brand. And even though you were there first, you might find yourself actually having to cave in and give way to the second brand because they have just invested much more and they're the stronger party. So it's a really difficult thing to look at, and that's why applications and registrations early is really, really important. Also thinking about in the context, if you are a small startup but thinking towards the future that you might want to sell to a big company, that's a key thing that they will look at. Have you thought about trademarks and brand protection? Have you put the applications in place? That will give your brand value when you're selling it later on. And when the due diligence is done around the brand, it already is a step further that makes you more attractive to potential purchases. Now, the other thing we find is trademarks are often not protected adequately. So when we think about protecting a brand, really, there are certain things we have to think about. The main things that we need to look at are the following, really. So first of all, which marks brand usage should we protect? Is it the word? Is it a logo? Is it a slogan? Is there anything else? And then thinking again about non-traditional trademarks. Do we have something that's unique to us? And then beyond trademarks, are there any other IP rights that we should consider as well? Once you've determined which elements of the brand to protect, the next thing you want to look at is which countries do you want to protect your rights in? And that, again, you can think about things like, okay, Like maybe the UK is my big market, but I'm thinking about branching out into Germany and France. Maybe I should protect in the EU. And what does it look like a few years down the line or a few months down the line? Am I going to look at the US, China, and where am I going with this brand? So that should be thought about at the outset, so that you can put a strategy in place and really, really develop, knowing which ones are your core markets. And then finally, which goods and services do you need to protect under the brand? Now, trademarks are not protected in relation to everything. If you apply for a trademark, you have to really know what you want to protect it for. So they are really, they're protected with respect to certain classes or categories of goods and services, um, and not everything. So we often find that companies that are smaller, or sole traders or smaller entities, they go ahead and they file a trademark application because it's quite easily done. But what you then find later on is that maybe the protection was too narrow or it was done in the wrong class. It's not really giving you protection for everything, which then would necessitate a second filing or maybe even a third filing, just thinking about all of that. So really important to think, what is it actually I'm doing under this brand and have I protected all the elements? Going beyond protection, actually, again, a very frequent thing is not keeping a watch on third parties. For example, are there competitors or counterfeiters out in the market that use the same or a similar trademark? Well, trademarks don't enforce themselves, brands don't enforce themselves. It's really up to brand owners to monitor third-party uses and registrations. And many companies, even larger ones, do not actively monitor all third-party users that might be out there. Unfortunately, that means it makes brand protection a little bit valueless, because if you're not enforcing your rights against third parties, you will have people subsequently in the market, and that will always dilute your protection to some kind of degree. Of course, always have to think about commercially vis-a-vis budget. Maybe you're not going to watch every brand you have. Maybe it's just your core brands. Maybe there are certain things that you would take more or less action against, depending on how bothered you are by certain uses. But definitely putting the relevant things in place is something to consider. I guess that's almost making me move on to the next point, and really, what are the winning top brand protection tips for any brands? So I may have touched upon some of these in the last section, but really, what do you need to do to ensure that you are protecting your brand or brands and you're adequately creating value? Now, yeah, I say it again, the first thing that you need to do when you're looking at brands is a trademark clearance search. And what a trademark clearance search does is basically a search and analysis of the trademark databases and other resources to determine whether a chosen trademark is available for use and registration. This should be done really, really early before you even start using a proposed mark, actually during the conception stage. If, for example, you're a bigger company with a marketing team considering 5 names, clear them early so you know which one might work. If you're smaller, even, as you might get really, really attached to a certain name, but do the searches early. Some searches you can do yourself online, but it's always important to note, just if you go to the UK intellectual property website and you put your name in and it doesn't come back and you think it's available, that doesn't mean it's necessarily available, because there could be similar marks that your search isn't revealing. And then again, you have to think about the territorial nature of things. If you're only in the UK, a UK search is sufficient, but perhaps you need to look a little bit broader than the UK and look beyond that as well. And really, these searches are relevant if you're creating a new product, if you're expanding your product into other countries, at any stage, really, when you're doing brand name development. And so once you've done these searches, then of course, it's really important to consider the appropriate trademark filing strategy. And again, this is really which marks should be protected, where should they be protected, how broad should the protection be? In that again sense, it's always really, really important to seek the necessary advice. If you don't have that in-house, it's always worthwhile speaking to a trademark attorney or a lawyer. What they can do is devise filing strategies globally, looking at things like your core brands, key markets, and budgets. So if you, for example, as a startup, have a very limited budget in the beginning, you could get advice around what do I protect first, and then if that's successful, how do I go on here? How do I shape my strategy? What do I prioritize? So that's a really helpful thing to do. And once you have that trademark filing strategy in place, then of course you should file the relevant trademark applications to go with that in the relevant countries that you have identified in your strategy. I've mentioned enforcement before. So as I say, really important that you have, once you have that robust and intellectual property portfolio for products and brands, you need to monitor those. You have to police your rights. You have to make sure you recognize infringements by third parties and take action where necessary. And that's especially so when it's a really important brand to your business. Um, and that's again, sitting down and thinking about what would bother me, what would I take action against, and what could I live with. There's many different types of watching services, and again, it depends on your product or brand, which one you might want to choose. The most common thing that we do is a trademark watching service, so that can monitor the trademark registers around the world. You can also monitor other things for company name registrations or internet traffic for third parties. Really dependent on what your needs are and what you want to shut down, really. And normally trademark watching services, we would say, set them up at the filing stage or latest at the registration date of your first filed trademark. And then, that relates to it, put a trademark enforcement strategy in place. As I say, you really do need to sit down. You have to think about which one of these uses would bother me. What would I prioritize? Maybe my house mark, so my name and my logo, I would go against everything that's similar. But if it's a sub-brand, maybe I would only do it in certain territories. For example, UK is my main and EU. But if it's somewhere else, let's say in Australia, maybe you have a mid-sized strategy where you might just go against things that are really in your space, but not as, you wouldn't go against everything. It's really sitting down and making a little kind of a plan. It's almost like a tier strategy and thinking about how you would do that. And also what you need to think about in that enforcement strategy is, are you aggressive? Are you more, amicable? What kind of settlement agreements and undertakings would you want from third parties? There's quite a big package to think about. This seems obvious, I guess, trademark renewals. When you are working with a trademark attorney or a lawyer, what they have in place generally is a trademark docketing system where they will keep in place trademark renewal dates, because as I said before, you can have your trademark rights forever, but you need to pay the renewal fees every 10 years. And so it's really important to keep an eye on that, keep the date somewhere in a safe place, a diary. The best is the trademark docketing system because it generates reminders in advance, and you can attend to renewals as you need them. But really important to keep a track of that, because otherwise you could lose a right inadvertently, and that can be also quite a costly thing as well. Now, another point on trademark portfolio management. So the best managed trademark portfolios are really those who are looked after on a proactive rather than a reactive basis, looking at not just one case individually, but at a portfolio as well as strategies as a whole. So that you're just not doing it reactively to one case, but you're actually thinking, what am I trying to achieve? What does my strategy look like? And then also looking proactively at, if there's any gaps in protection or anything like that you want to plug. So what it really does is by actively managing a trademark portfolio and not just letting it sit there and reacting to things. If you get a trademark watch notice, you might find opposition. If a renewal comes up, you might deal with it. But actually sporadically looking at it and actively managing it means that you have consistent approaches to filings and enforcement strategies. And what it then also means, it adds value to your business again, especially if we're looking at the scenario where your business might be sold off in the future. Having all these things in place is actually quite helpful. Trademark portfolio management can be done in-house if there's somebody passionate and qualified to do it, but it also can be done by law firms or trademark attorney firms. And related to that, as I briefly touched upon, is trademark portfolio auditing. Now, trademark portfolio auditing goes hand in hand with trademark management. For larger businesses which have a lot of rights in particular, it is really worthwhile conducting an audit from time to time. And that's to identify gaps in protection and address these gaps. You want to kind of look at these gaps in view of your current portfolio, your business, and future strategy. Strategies change. You might have to adapt certain things. You might find that certain rights are not necessary anymore, and you might want to abandon them, which could save money in turn. And so, that way you can reduce costs as well. So it's really, where do I need to plug the gaps, but where can I let things go and make sure you have a really lean portfolio in terms of not any unnecessary costs, but also a very robust portfolio in the sense that you have protected everything you need to protect. And finally, trademark licensing. It's a part of trademark portfolio management to think about these things as well. and look at the value of your trademarks, because of course, in the sports world, especially including tennis, brand licensing is hugely important and an important source of revenue. And so having proper license agreements in place to strike a balance between the licensors need to protect its brand, the licensees wish to make the best commercial use of licensed rights is really, really important. So that's also something in the trademarks and brand protection aspect to be aware of and think about when you're trying to maximize value. Now, I have been asked actually to think about this a little bit in view of our members and to really think about what the value of brand protection for tennis brands and tennis clubs is. Because it's very easy to look at this in abstract to give some cool examples, like I did at the outside of this kind of seminar. But when you're then taking it back to how does this apply to me and my company, obviously we have a broad range of members and everybody will be in a slightly different position. The area of trademark and brand protection is of course hugely detailed. And what I hope is that this webinar has given you a good overview over the key aspects to consider. So if you're then looking at the different kind of people, companies that may be watching this webinar today, established companies in the sector are already likely to have considered their protection, but I hope I have been able to provide a few key takeaway points or refreshers to consider, because even the most sophisticated companies really could benefit from taking that step back and considering whether their current protection is robust, looking whether anything is needed in their portfolio, whether there is anything that needs to be plugged as a gap, whether all the countries have been protected, or whether there's things that you can let go of. And also, obviously, established companies that are bigger, they will develop new brands. And so every time that you have a new brand, these are things that you need to consider again from the outset in terms of clearance, filing, what is my strategy, how do I go forward? Now, I think the main message is really for the smaller companies and startups. And I think the message there, which I've said throughout, is that they should really start considering brand protection at an early stage and carry out the relevant searches early and put in place brand protection strategies early before competitors get there. It can be really disappointing if you have the next great thing that you developed, whether it's a product or a service, and you haven't dealt with the trademark and brand protection, and then you find as you're going down 2-3 years down the line, you might not be able to have that brand. You might have to rebrand when you've already created some kind of value in it. And also, as I said before, if you then come into selling stage, maybe some bigger companies saw your product and is really willing to pay you lots of money for that. At that stage, if they're finding you don't have the protection for it, you might have to think about rebranding. It might lessen the value of the great thing that you've created. And then finally, if you're a manager of a smaller local tennis club in the UK, you may wonder how relevant brand protection is to you. I must fully confess, it is probably a little bit less relevant to you than to a company that is producing products and putting out services and is merchandising them. However, creating a strong brand can be very helpful to attract new members and revenue generation. So, for example, if your club has something that sets you apart from others, your clay courts or indoor and outdoor courts, so you can play all year round, but regardless of the weather. Maybe you have a star tennis player as an alumni, or a highly rated coach or coaches. Maybe you even have a talent scout working at your club who may discover that your daughter or son is the next Wimbledon champion. If your unique selling point is associated with your branding, it may well mean that more people come to your club. And it can also help you stand out and help you make it more memorable. So the brand is more memorable. And as we said at the beginning, intellectual property rights play a huge role in the growth and development of the sports industry. They're at the heart of a number of business transactions, again, sponsorships and merchandising. And so at least protecting your core brands may be worth considering. Do you want to register your word mark? Do you want to register a logo? Might just be UK if you're a small UK club, but there is certainly some value to it, and it's not terribly expensive either to consider that kind of protection. Now, thank you for listening. If you have any questions, please feel free to reach out to me. You can either contact me on the contact details provided here on the last slide, or I'm also very, very happy to connect with anybody on LinkedIn and take these discussions further. Thank you so much for listening and have a good day.
Thanks for watching this webinar, and if you have any questions or queries on this particular subject, please email phil@tiauk.org.